Good day, my name is Mariam Allie. I'm a legal advisor with SEESA in the Consumer Protection and POPIA Department based at the Cape Town branch.
Hi, my name is Asheer Dollie, along with my colleague Mariam. I'm also a legal advisor at the Consumer Protection and POPIA Department at the Cape Town office.
Today, we'll be discussing the concept of openness as required by the POPIA Act, and specifically focusing on the requirements of Section 17 and 18 of the Act. We will further delve into the consequences of non-compliance, as well as indicating measures which you as a company can implement to ensure your compliance with these sections.
So Condition 6 of the POPIA Act relates to openness, and basically it's regulated in terms of Section 17 as well as Section 18 of the Act. So openness basically, the concept of openness relates to the interaction between the responsible party and the data subject, and that the relationship between the two remain transparent and open throughout.
And as Asheer mentioned, it's the question of transparency. So Section 17 indicates, or in a nutshell, that every single company, whether it's a public or private body, must have a POPIA manual in place. POPIA is the Promotion of Access to Information Act, and the aim of this act is to promote transparency and accountability by public bodies as well as private bodies. So the POPIA manual that has to be in place must reflect the company information, the types of information collected and processed by the company, legislation which they comply with, as well as the access request procedure followed by the company. Now, POPIA is an older act. It was enacted in the year 2000, and it used to be overseen by the South African Human Rights Commission. However, that obligation is now being conferred on our information regulator from the 1st of July 2021. The information regulator has released an updated template of that POPIA manual. So companies must please ensure that their POPIA manuals have been updated for those who have POPIA manuals, and those who don't have, please ensure that you implement one, as the deadline for compliance was the 1st of January 2022. So that deadline has since passed.
So as Mariam touched on Section 17 of the Act, I'll just touch on Section 18 of the Act. So Section 18 of the Act places obligation on the responsible party to, when they process personal information, that they take the reasonable practical steps to make the data subject aware of the following. So 1, the personal information being collected, and who is it collected from, if not directly from the data subject. 2, the name and address of the responsible party. 3, the purpose for the collection of the personal information. 4, whether the supply of the personal information is mandatory or voluntary. And number 5, if the data subject fails to supply the personal information, what are the consequences thereof. Number 6, if there's a legal obligation on the responsible party to process that personal information. Number 7, whether the responsible party will transfer that personal information to a third country or international organization, as well as the levels of protection afforded to that third country or organization. Furthermore, you have to inform the data subject of the following. If the personal information will be transferred to a recipient in terms of a third party or independent service provider, as well as the nature and category of personal information being transferred. You also have to inform the data subject of their rights, and the rights in particular include the right to access personal information, the right to rectify the personal information provided, the right to object to the processing of personal information as stipulated in Section 11.3 of the Act, as well as the right to lodge a complaint with the information regulator as it relates thereto. There are exceptions to non-compliance with Section 18. However, we advise that before you want to follow through with non-compliance of Section 18, that you please consult the legal advisor before following through with that. In terms of punishment, if there are any breaches or contraventions of the sections or provisions of the Act, you can be charged with a fine up to 10 million rand, as well as possible imprisonment depending on the seriousness of the breach.
Thank you, Asheer. So in order for you to avoid, or in order for companies to avoid liability, we recommend that you put the following measures in place. In order to comply with Section 17, we recommend that you ensure that you have a POPIA manual. And if you have an older version of the POPIA manual, please ensure that it's updated. For the purpose of Section 18, speak to your legal advisor, contact SEESA if you aren't an existing client in order for us to assist you with the formulation of a privacy notice, a privacy policy, and further documentation in order to ensure that your credit application and any further documentation which you use, in which you collect personal information, complies with the requirements of Section 18.
In conclusion, if you would like to satisfy Condition 6 of the Act, or as well as the Act in itself, please contact a legal advisor at the SEESA department, especially the SEESA Consumer Protection and POPIA department, and we'll be happy to assist you in compliance thereof.